amendments you would like to make?
Yes, Civil Code 1941 and 1942. I'm not able to make no money off this commercial unit because we cannot occupy this unit because it's unsafe for people to be in. So, and also Civil Code 1174.
Research attorney, I'm still doing that on the fly here.
Yes, sir, I understand.
Dates back to the year 1873. Hasn't been amended since 1873. There's not many laws in California that can say that. Mr. Rowe, do you wish to be heard? Any final arguments? Oops, I'm sorry, you're muted on your end. Oops. There we go.
Thank you. Yeah, Civil Code 1941, which pertains to when the defendant just referred to, starts out, the very first two words are a dwelling shall be deemed untenable, and then it goes on to give those things and the reasons. Also, in the defendant's own answer, she attached a message from RK Group. It's dated January 30th. At the top it says RK Group, and it says, "Hello, Miss Crooks. Hope this message finds you well. My name is Rena. I'm the owner of 1846 Parsons Avenue, Merced, the building you currently occupy. I want to reach out and apologize for any confusion that has arisen regarding the lease and management. To clarify, the unit, let's see, Ileana will be your main point of contact. Please work with her and her team directly. I attached the 2 formal letters from Select Property Management as well for your reference." That's in her answer.
Signed by Kevin.
So her whole plea that she never heard from RK is simply not true. She attached that. Our position
Signed by
is
Kevin.
that Select told her where to pay it and put it in that 3-day notice. She can't ignore that and just say, "Well, I didn't feel like I was getting the communication that I should have gotten." You can't do that. If it's in the 3-day notice and they previously notified you that that's where it is, then that's where you pay. Then you can argue about it later. But if you don't pay, then you are in breach, and that's failure to pay and the notice expired makes it such that with a commercial tenancy, plaintiff is entitled to judgment.
Negative.
Okay.
May I speak, sir?
Sure. Go ahead.
Okay, yes, and within that attachment, if you read at the bottom of it, it actually makes it illegal because it's someone else that signed the end of that email. And it made it illegal for someone else to forward somebody else's name and pretend like they them.
Okay. I'm prepared to roll. That didn't make it illegal. I think you were provided notice of the property manager, and the owner of a property is certainly entitled to appoint an agent or property manager to work with tenants. The plaintiff provided sufficient evidence of all the essential elements for unlawful detainer based on a commercial lease and a 3-day notice to pay or quit. What I've been grappling with this afternoon is what defenses are applicable in a commercial tenancy. The habitability defense, the implied warranty of habitability, the repair and deduct statute that was cited here. These don't apply to commercial tenancies. I'm going to find for plaintiff, and I'm going to find there wasn't sufficient evidence to prove a valid defense in this case. That's not to say you don't have contractual dispute with the landlord in this case. It's just in this limited setting of an unlawful detainer case, I don't find that you've met your burden of providing a defense for the failure to pay rent. So I am going to find for plaintiff, they're entitled to possession of the premises at 1846 Parsons Avenue in Merced with rent due of $4,500. The holdover damages of $5,500, attorney's fees of $400, costs of $340, and lease agreement is canceled, lease forfeited, and the lease agreement canceled, and it applies to all unknown occupants. Ms. Cooks, do you have a right to appeal the court's decision here today? You need to file the notice of appeal within 30 days. You can find information about appealing the civil judgment on the California court's website. Again, I don't know enough about your other case to understand how it applies here, but based on the contractual defenses I heard today, I didn't have sufficient evidence, admissible evidence, to find my proponents of the evidence in favor of those defenses.
Yes, because at the end of Civil Code Section 1941 and 1942, at the end it says which could be applied to commercial property as well.
Where does it say that?
Can you get us to in front of me, please?
I'm looking at 1942, I'm looking at 1941 here on my computer. Is 1941 is for the lesser of the building intended for occupation of human beings, and that's someone's summary. That's not the actual code. I'm actually looking at the words here of the statute in front of me. That's someone else's summary. Okay, and again, if you wish to appeal on that basis, the appellate court, any issues of law, they'll look at that. They'll review that.
Okay.
Mr. Rowe, you will prepare the judgment.
I will, Your Honor. Thank you.
Okay, thank you. That's the court's review. We'll call that in a moment. I'm going to hang on to the exhibits that were submitted in this case, unless they're your originals. You can retrieve those from our clerk's office, but we're going to hold on to those for a period in case this matter is appealed.
That's fine, I have copies.
Okay.
I appreciate you.
Thank you. And let me just.
So, anyways, that was the conclusion of that.